Yes, Miss.
Thank you
Where
very
do you want
much.
to go to, or what do you want to say? Do you
I
want
just
to
wanted
come
to
back on something?
Just re-articulate, if I might, the answer to the question that my
Yes.
Jeremy Baker posed just before lunch, which is we're not arguing that there's an obligation on the state to make the appellants less poor, but to protect her from harm or risk of trafficking if she seeks work. So without there being a risk of her being in servitude, and her motivation is economic survival, not trying to get a better job. So that's why we say that it is not a question about reasonableness, and that we say the state has been unable to protect the appellants and would in the future do so from recruitment practices that are corrupt and deceptive. And in our skeleton, just because I haven't taken you there, but I don't need to, I hope I don't need to, because in our skeleton argument at paragraphs 44 to 49, we go through the trafficking in persons report on the Philippines 2022 that's in the authorities bundle, but I don't want to turn up for reasons of time, because it is, unless the court wants to go there, which confirms that how the traffickers exploit victims. They typically do it in partnership with local networks and facilitators. They recruit unsuspecting Filipinos through illegal recruitment practices, and also corrupt officials are involved in the process, that's government officials, to facilitate illegal departures for overseas workers or overlook illegal labour recruiters. That's paragraph.
You've highlighted this in your skeleton, and have you flagged the relevant passages? I don't want to take you to just. I want to make sure that we don't take any. If the answer to that is yes,
the answer is yes, because I think it's and importantly in paragraph 44 in EAV in the decision letter, the secretary of this is at 44 of our skeleton. The Secretary of State expressly accepted that the authorities were unable to protect her from illegal recruitment practices, which the Secretary of State said were prevalent in the Philippines. The reference is there, the bundle reference, and the paragraph quote 17. So that's in the decision letter in EAV and the trafficking in persons report in the bundle in our skeleton. The Secretary of State's own CPIN at 46, which says traffickers prey on the most economically disadvantaged. And that is the most common human trafficking recruitment method is false promises of job placement. That's in the Secretary of State's CPIN November 2022. In the bundle, the references are there in the context of both sex trafficking and domestic servitude, involvement of state officials, and then the references at 47 to 49 in the skeleton argument also refer to GMP and the decision, the conclusive grounds decision minute, which confirms that she applied for a job overseas in order to support her and her children after her husband had stopped providing with financial support. That was the unchallenged position. So that's the factual position set against the objective materials such as they are between in the bundle. So I don't have to take the court there. And the final proposition was just to come back to the immutability point on the PSG, which is that it's right that we've looked at gay men in Iran, we've looked at impact women, but there's no suggestion that one could tell immutability and recognised in society doesn't mean recognisable by looking at a person, just recognisable that they exist, because you can't tell whether a woman's intact by looking at her, nor can you tell whether a man is gay by looking at him. So that's what I think it's we cited slightly seem to be sliding into immutability and recognition in society of groups in a sort of in a different way about it is perception. Well, it's
perceived to be a group.
Yes. I just wanted to
not by visible means, but there is an understanding or an acceptance that that group exists as a group apart from the rest of society.
Yes, that's all. I just wanted to make it clear that we haven't gone too far on that.
Yeah.
And then the final case I wanted to take you to, and going to take it probably very briefly, was RT Zimbabwe, which is at tab 17, page 408 of the authorities bundle. And this is just the follow-on case from HJ Iran. I can put it in those terms. And you can see from the head, which is the issue was whether a person who could not be expected to change his identity, or because they were closely linked to his identity, or were an expression of fundamental rights. And that, in this context, applying HJ, was a person who had no political beliefs, but if forced to return to Zimbabwe, may be forced to lie and feign loyalty to the regime to avoid ill treatment. And as we say in our skeleton argument at paragraph 21, and also emphasised here with reference to paragraph 25 of the judgment, which is at 45. Let me just get there. That, and this is in Lord Dyson's judgment, paragraph 25. It's well established that there are no hierarchies of protection amongst the Refugee Convention reasons for persecution, and the well-founded fear of persecution doesn't change in according to which convention reason is engaged. And I think that's important, because here, with the court wasn't concerned with somebody who had a right to a political opinion. It was the right. It was a person who didn't have any political opinions, but who'd have been forced to profess some in order to avoid risk of harm. And that's, I think, is so. Rather than focusing simply on HJ Iran and the right to identity as and to live openly as a homosexual, this is notwithstanding this was a right not have to express a particular political belief. That the court still concluded, it says at 26, the HJ principle applies to any person who has political beliefs and is obliged to conceal them in order to avoid the persecution, if he were to reveal them. And then in the 29, what about if the person has no political beliefs, and the court pretends they do? And that was what the court concluded at 30 by reference to the human rights framework. The emphasis on the importance of human rights in the present context is in the Council Directive and that was how the court reasoned that there would be such protection for a person who did not have any political beliefs, but would be required to express support for the ruling party. And so we are saying, and of course it's analogous, that the right to seek work without fearing trafficking or enslavement when legitimately seeking work is something that is within the protection of the Refugee Convention when viewed through the prism of fundamental human rights and respect for human dignity. So I don't think I need to say any more about that. And that's the end of the tour, if I may say, through the cases. And then we just come to what is the application to the relevant factors we have from here. And starting with EAV, I just wanted to, let me just get the bundle of EAV's bundle, sorry. So this is dealing with core bundles in each case. In EAV, the first tier tribunal accepted that if she were to return to the Philippines, she'd have no choice but to seek employment overseas, even if this was at real risk of re-trafficking. Paragraph 15.
Should we just find that?
Yes, that's core bundle 59 of EAV. So the primary question I must ask is whether the appellant, if she will return to the Philippines, would be at risk of persecution. Much of the background facts are uncontentious, and I remind that there's no challenge to the expert materials in either of the cases. I think I'm right in saying she's from a poor family. This is no fault of theirs, but the consequence of their economic situation they face in the Philippines. She sets out the situation of their family members. The reality is the entire family is struggling to meet their basic needs, and then the appellant describes what she approached what should have been a legitimate employment agency. The agency failed in their obligation to carry out the checks. The appellant set out the competent authority accepted she was trafficked. The appellant would not likely leave her family and daughter unless there were no alternatives in the Philippines. And so, in paragraph 17, that the accepted evidence is she'd have no alternative on return. And paragraph 18 is just the point that we had from earlier, just to emphasise that this is where we say the Secretary of State's grounds of appeal and the upper tribunal went into error, because the judge said, I don't find it likely she should be targeted by any particular individual, and that's why the no relocation or sufficiency arose. But that question of targeting was then taken, we say, out of context, and then that's where the upper tribunal erred. But
well, let us just maybe just read again for
part,
ourselves.
yes.
18.
18
I think is the core part of the FTT.
therefore, yeah.
Yes. Does the FTT tribunal judge say in terms that EAV would be at risk of persecution in the Philippines?
She says, paragraph 20, by way of conclusion, I find there's a real risk of the appellant being re-trafficked out of
Economic necessity.
Yes.
Well, that's not the right test, is it?
I mean, we've hit you with two questions, Mr. Knight.
Sorry, so that's
there were 2 points here.
Yes.
The first is, is it she, Judge Farrell? Where does the judge say that the risk of persecution arose in the Philippines? And the second point, the latest point is, isn't the risk of being re-trafficked out of economic necessity
this is
rather than membership, I'm paraphrasing, membership of the PSG?
So when she concludes by saying she's at real risk of being re-trafficked out of economic necessity, this happened before, her individual circumstances and history of reaching this conclusion. This doesn't mean she could continue to fight mistreatment and recover so well. The historical account that she has, that she's identified, and going back to paragraph 15, the primary question is whether if she's returned, she'd be at risk of persecution. The accepted account and backdrop is that which we've been through, which is that the recruitment took place in the Philippines. There's a positive conclusive ground decision in this case from the Secretary of State for the Home Department. And it might be useful I didn't mention it earlier, but it might be useful to go there if the court wants to remind itself that's in the supplementary bundle, which is in
Yes.
EAV.
So is this helpful to look at it now while we're trawling through?
Well, okay, let's.
So the question I'm asking is, let's make the same question as the lady. There are two strands. First of all, where does the judge say the risk of persecution arose in the Philippines? And where does she say the risk arose on account of her membership of the PSG that we have identified?
I'll answer the second question first. The membership of the PSG was accepted by the Secretary of State in this case.
Yes.
And so that, which was the Secretary of State accepted that she was a member of the PSG, former victims of
But where
trafficking.
does, don't forgive me, I think Milady, I know Milady, confident Milady's question is, where does that's a given, but where does the judge say that the risk of persecution arose on account of or by reason of
Well,
the membership of the group?
yes, because it wasn't an issue. She's reached the conclusion that both parties approached this case, both in the appellant and the Secretary of State, that the membership of the PSG wasn't an issue, and the only question that arose was, would there be a real risk of re-trafficking?
Causation was always an issue. It had to be. In order to satisfy the test, you've got to have causation. You can't simply say, oh, well, nobody actually turned their minds to it. What the judge has done here is said the reason that she's at risk of re-trafficking is economic necessity. She finds as a fact that she wouldn't be targeted by anybody in particular because she's been trafficked before. That is completely cuts across. Now, it's a completely separate point from whether or not the upper tribunal got it right, but speaking for myself, it seems that she has applied the wrong test.
But my lady, if I can just cut the conclusion that she wouldn't be targeted is one we accept, for the reasons that we went through this morning about why she wouldn't be specifically targeted by a particular set of traffickers. But the way in which the whole case was framed and the risk on return was framed in relation to her being at risk of a
Persecution.
risk of persecution. Sorry, I just.
By reason of being somebody who'd previously been trafficked.
Because it was a repetition of her past experience. That is how that.
So having heard that submission, can I just reread?
Okay, so just go to paragraph 18. Actually, sorry, that's Miss Lou's reminder. Then she says, so I've highlighted there may be the last sentence. She might be fortunate to find a good employer. There may be a repetition of past experiences. In assessing the risk, I've had regard to her personal circumstances. I'm not suggesting there's always a risk of persecution of individuals with economic difficulties. So she's identified the persecution, which is the risk of being re-trafficked, repetition of her past experiences. This is in the circumstances where it was accepted by all that she was a former victim of trafficking. And then she says, the risk of being re-trafficked arises out of economic necessity, i.e. that was the causative question as to why she would seek employment abroad, not the on account of, but the question as to why she would seek employment abroad. Read fairly in the context of the way in which the case had been run and concluded, that is, in my submission, is why the first tier and how and why the first tier tribunal reached that conclusion.
I mean, the alternative interpretation is that the membership of the PSG, as you've characterised it, and which was not contested, was a feature of the history, but not found by the court to be the cause of any risk. But the cause of the risk was economic necessity. The risk of being re-trafficked was economic necessity rather than membership of the group, which she was.
Well,
and one might say, you took us to 18, and I think Milady's already highlighted to this, the first sentence of paragraph 20, on the face of it, would seem to say that in terms. I think that's Milady's.
well, my lord, and my lady, I can only resist very strongly that interpretation by reading the decision as a whole in circumstances where the particular social group was accepted, and she does what she is obliged to do, is to see whether she'd be targeted by anyone in particular. That's entirely consistent with the appellant's case. That's not her case.
You would invite me to do what Johnny's obviously the counsel, which is to read the next sentence, wouldn't you?
Yes.
Which is, this happened before, I bear in mind every circumstance and her history in reaching this conclusion.
Yeah, and the economic necessity is part of her vulnerability,
Yes.
which is identified at paragraph 15, and at paragraph 16, she says in terms that the that the appellant would not likely leave her family unless there were alternatives in the Philippines. So she's setting out she's setting out what she would do, the fact finding of what she would do, not the reason for it to do. And even if as part of it is part of her case that the reason she's seeking employment abroad is because of or on account of economic necessity. But that's the factual causal position. That's not the why she's being persecuted.
It does come down to the interpretation of 20. You say paragraph 20 should not be read sentence by sentence, but should be read as a whole, and that the risk of retrafficking, risk of persecution is a combination of her history and economic necessity. Is that it?
The risk of persecution rises because she says there's a real risk of her being re-trafficked, and that it isn't on account of economic necessity.
But it's got to be on account of something. It's got to be on account of her belonging to a particular group. And the trouble is that I can't, try as I may, read the first sentence of paragraph 20 as anything other than saying the reason she's likely to be re-trafficked is because of economic necessity.
Well, we say it's.
You say the word "we" before traffic is important.
we say that in economic necessity is a shorthand for explaining why she'd be in the situation that she would be in, and that is not what we say is not controversial, particularly when you go back to looking at what the upper tribunal finally conclude. They very clearly say that they accept that she would be at risk of real harm in the future. The question as to why she would be putting herself in that position is on account of economic necessity. That's part of her case. That's why I think I opened this afternoon by saying, just go back to what I actually said, which was that she, out of economic necessity, is seeking work abroad. That's absolutely part of her case. But the reason she'd be persecuted, and the reason she's at risk of being trafficked isn't out of economic necessity. It's out of who's being targeted for that.
We're back to the fact that everybody who would be at risk of being trafficked would be economically vulnerable. Every single person in the Philippines, male, female, child, whoever.
But we're talking about that's to define.
And the fact that they've been trafficked before is neither here nor there. It's a total irrelevance.
Well, my lady, just to take those points separately, the first point is that everybody who's at risk of being trafficked is not at equal risk of being at equal risk. The issue here is who is being targeted who are the traffickers targeting. They're targeting particular women in the Philippines and also children, but for different types of exploitation. That much is absolutely clear from the evidence that was uncontested evidence that was before the tribunal.
If I may say so, I do think paragraph 20 is where you will have to say you find the decision, because read as a whole, it's not just economic necessity, it's re-trafficking, having happened before, bearing in mind her history.
That's right.
I mean, it's not put as you would have put likely to be put, nor as you would like us to put it, but that is the ratio. That's where the judge is making the finding which you're seeking to.
The risk of re-trafficking arises because of her individual circumstances and history, and that is as a former victim of trafficking. That's exactly what the PSG was accepted to be. Back to the particular characteristics why she's vulnerable, and so I don't accept that everybody in the Philippines is at risk of trafficking. That's not in any way how we put our case and in any fair characterization of it.
No, okay. Now, you may remember about 5 minutes ago, I very unfairly put 2 points to you, which is, forgive me for doing that.
No,
the latest point, and then I was asking the point, which really anticipates the upper tribunal's decision, which is, where does the judge find that there was a relevant risk of persecution in the Philippines?
Yes. So
the upper tribunal judge said that she didn't.
Yes. So the accepted paragraph 16. The middle of paragraph 16, it says the competent authority accepts that she was trafficked. and I did mention this earlier, but I'm just going to take you to it now because I think it's important.
Yes.
Which is the competent authority, that's the decision-making arm of the Secretary of State, accepts that.
And that includes the recruitment process.
The recruitment process, and I think we started there this morning,
Yeah.
and I gave you the references in the CG, the conclusive grounds minute that accepts that the appellant was recruited in the Philippines to work in Saudi Arabia. The agency staff accompanied her to Saudi Arabia, assisting her through immigration, and so it is.
Is that in the, where is that?
Sorry, that's in. So the conclusive
Supplementary.
Supplementary bundle. Let me go on to paper. That's page 224. It starts at 224.
Yeah.
Supplementary bundle for EAV tab 54.
Okay.
So effectively, you're saying you can extrapolate from the fact that it's accepted that the previous history involved trafficking in the Philippines,
Yes.
that when you're talking about a repetition of the same conduct, that also involves trafficking in the
Yes.
Philippines.
Hence, we went through that definition stage and everything else. And
Okay.
so,
Right.
if you want the relevant pages, it's page 230. Incident 1 involves Philippines.
Yeah.
231 trafficked via recruitment agency in the Philippines, by plane, accepted job, and 232, the top of the page, your first paragraph, in the Philippines. So 233, penultimate paragraph. Overall, it's accepted you're recruited to work for family in Saudi Arabia, transferred and transported from the Philippines by the agency staff, harboured and recruited, and that was by means of deception and conditions of your employment. So I think there's no doubt in relation to that. I'm happy to take that more slowly if
No.
I think it's uncontroversial that hence the point about rather painstakingly, if it was on my part, going through the stages so that the holistic picture of the trafficking could be understood, the action, the means, and the purpose point. So that's where we importantly we say the appellant had a detailed asylum witness statement. Again, we don't need to turn it up, but for your note in supplementary bundle for her, page 152, there's a very extensive witness statement, and the material parts of that are at 178 to 9. Again, just because there was effectively, as both all the tribunals indicate, there was no challenge to the primary facts, and that's in some ways what makes this case on one level more straightforward and on another level quite complicated. But the one thing we know is that nobody was, apart from the motivational point in GMP, that all the facts and the expert evidence and all the background materials were.
So at this point, the point of where the persecution had it occurred in the Philippines, there was consensus. It wasn't an issue between you.
No.
So why did the upper tribunal judge come to a contrary conclusion?
Well, the upper tribunal. So
did she not? Then I misread
the
it.
upper tribunal judge. Let me just take you to one before we get to the upper tribunal judge. Can I just say, take you to the grounds of permission from the Secretary of State.
It wasn't clear from paragraph 18 on what basis she fell within the Refugee Convention. That was
Yes,
the ground.
the Secretary of State said it was that she wasn't being targeted at
Okay,
the
I misread
starting
it.
point in the Philippines. That's page 52 of the core EAV core bundle. So therefore it was unclear on what basis she was said to risk persecution, and she wouldn't be targeted there. And the ground 3 was that the tribunal appeared to conflate her consideration under the convention with those relating to economic migrancy. So let's go to the upper tribunal now, and the starting point there, importantly, actually, yes, we'll come to that in a minute, but if we go to paragraph 5, she says that the upper tribunal say that the judge found it wasn't likely, paragraph 5, that the claimant would be targeted in the Philippines. And then, which it is correct, but it's not the whole analysis, because the analysis then is the question of how she would be at risk of trafficking. She then leaps to the point in paragraph 20 that my lady looked at without looking at the intervening points, which were what was every single thing she'd said in her witness statement was accepted. All of her background materials were accepted, and so reading it properly and fairly, it wasn't that the risk arose out of economic necessity. It was that those were the circumstances in which she'd find herself exposed to the risk of re-trafficking. But there's nothing that the question there is that summary is a conflation, we say, of a proper interpretation of the evidence, all of which had been accepted.
I was looking at paragraph 18 at the top of 39.
So,
where the judge,
yes,
the tribunal judge seems to have read the first tier tribunal judge's observation that the claimant would not be targeted by an individual in the Philippines.
Yes, and she's extrapolated. Yes.
That's one particular risk of persecution.
The claimant fear would only occur if she made a choice to seek work abroad again, but that's a misunderstanding and a mischaracterization of the risk of trafficking that we have been through, and also how the case was presented to the tribunal in relation to the recruitment being in the Philippines and the risk of arising there. Those were the accepted facts. So in my submission, that is a clear error on the part of the upper tribunal.
I don't think the upper tribunal is saying any risk would only occur abroad. I don't think that's what they're saying at all. They're saying paragraph 18 of the lower tribunal. There's no finding as to what the risk of persecution is in the country of origin. There's a positive finding that it wouldn't be targeted by anybody, and then the claim fear of persecution would only occur if she makes a choice, and that's really looking at the choice and the economic necessity, which is what you then go on to discuss in paragraph 19. So I don't think it can fairly be read as a suggestion that any persecution would only occur in the Middle East. At least that's not how I read it.
Paragraph 19, the second half.
18, 19 and 20, the judge is critiquing the first tier tribunal decision and says that the first tier tribunal did not fail to identify a risk of persecution in the Philippines. 20 therefore inadequately reasoned. Then she goes to remake the decision, which is probably where we should look to see how
Before we get to the remaking, could I just take you to the second half of 19?
Yes.
It asserted, which is entirely wrong, before the first tier tribunal, the claimant did not seek to argue that the economic circumstances of the Philippines in themselves didn't have a risk of persecution, or failed to identify a risk of persecution that she'd face in the Philippines. But the judge did identify the risk of persecution in the Philippines, which was namely the repetition of the past experiences, which is the recruitment in the context of trafficking. It couldn't have been clearer if there had been a proper reading. The recruitment, the judge made a finding that she risked having the same experiences and suffering those same things again. And the thing that she was always accepted was that she had been recruited by a trafficker in the Philippines, and that's what she faced.
So your first point, then, I'm sorry if I'm being dim, is that the judge was wrong to allow the appeal on grounds 1 and 3.
The judge was wrong to allow
and therefore shouldn't have got to remaking.
Shouldn't have got to, and that's in our grounds 3 of our grounds of appeal to this court, and that was identified by Lord Justice Popplewell and Lord Justice Lloyd on the papers, that they shouldn't have got to this point because there was no error in the way that is described, and then they shouldn't have gone on to remake because the findings were all there. The risk was identified. It was clearly the risk of the past repetition, which is recruitment in the Philippines, for the purpose of exploitation and transportation to the Middle East, where you'll be subject to the servitude. That was always absolutely clear in part of the appellants. The only way she put her case. She didn't put it any other way. She didn't say, I'm going to go to Saudi Arabia and then somehow something's going to happen to me there. It was always linked to, this is why I did take it very slowly on the structure of trafficking. And I needed to do that myself to understand it, which is the component parts, but they all what part of the chain.
I think what it really boils down to is the interpretation of paragraph 18 of the original decision.
Let me just go back to that again. So yes,
Because the first tier judge has not actually said in terms, this is the risk of persecution. So you have to read into it the identification of the risk of being, the risk that she says arises out of economic necessity as being a risk of persecution in the
but
Philippines.
yes, but if we read, she does say, this is in a case where all of the objective and background and expert evidence and facts were accepted.
I follow
And
that.
so I know that the tribunals are encouraged to make concise decisions, but they have to be read against the background material. So it says, the expert indicates it would be integral. So therefore, like many Filipinos, she will consider working abroad. She's economically vulnerable. Expert evidence indicates she'd be at risk because of this. It's my conclusion that there's being a real possibility that she would seek work abroad. She might be fortunate, find a good employer, but there is a risk of the repetition of past experiences, and that is precisely why it has to be read with, why we went to the case about past persecution and the past patterns and and her particular vulnerabilities. It is difficult because of it. The context is not. Because the context is, it has to be read with an eye to the trafficking definition. But all of those factors have been accepted. The conclusive grounds minute that I referenced makes it absolutely clear. The Secretary of State accepts that. So none of that is contentious. And the only question for the judge, aside from the PSG, which was also agreed, but the only question was, would it happen again? And the judge made a finding that because of her economic circumstances, that's a factual question, not the causal question, if you say. The factual question, she would, there's a risk that she'd do that again, and therefore...
Keep saying it was the only question for the judge. It wasn't, with respect. The question for the judge was whether it was on account of the fact that she was a member of a particular social group.
My lady, apologise. I do, obviously, that is part of the analysis, but...
Very important part of the analysis.
This part of the determination was addressing that question. And so we say paragraph 18 has to be read with paragraph 15 and 16.
And 20.
And 20. And the expert evidence, which is in the paragraph 13 of the judgment. So she says at paragraph 13, I attach weight to two expert reports obtained in light of their expertise and qualifications. Professor Siddle has set out the economic conditions in the Philippines and the prevalence of trafficking. The points he makes are relatively basic. The difficult conditions are fairly well known, and it would be typical for mothers to be forced to leave their children and work abroad, attract a great personal sacrifice to them and the family. Then she deals with the psychologist's report. So against that background and the accepted evidence, and I can take you to the appellant's lengthy witness statement if we need to go there, which is in the supplementary bundle. But she, in the supplementary bundle, the main statement, in her witness statement, it's tab 24, page 135. Of the supplementary bundle. She sets out her history as to why she'd gone to Saudi Arabia and all of the experiences happened to her. And then what she says, and again, this is all the accepted facts. I don't want to go, this is at page 152.
Want us to look at it?
Oh yes, my lord, if that's, we just go to 152 of the supplementary bundle. So, the history of what she went through.
Just a moment.
so
Is
sorry.
this tab? What tab is it?
Tab 24.
Got it. Thank you.
And the first part of her statement at 125, 135 sets out how she found the job, in particular through the agency, paragraph 21, all of this is accepted. And paragraph 28, 29 about the agency and how she was transported to the Philippines, that's between 28 and 32, and why she went there. And then the rest of the big statement, in some detail, details the abuse. And then she sets out at 163 her current situation. But what she says she fears, is the very last page of the witness statement, 178. I don't want to go through what I experienced before with my employer. I can't cope with being treated like that again. I'm scared of working for people like that, so they can get away with anything. They just treat you like an animal. I can't get a job that pays enough in the Philippines because I don't have contacts with someone who will take me. I'm a single mother, and it's only me supporting my daughter. If I go back to the Philippines, I'll have no choice but to work again in the Middle East to support my daughter, and I can't face that. And that's set against the background of the expert evidence and the accepted method of recruitment. Isn't that the appellant would just go to the Middle East and find a job there? Her case was that she would seek a job in the Philippines that would be located in the Middle East, and that is where the risk of trafficking arises. And with respect, properly read against this very complex legal and factual background, it couldn't be simpler on that single issue about the question of the risk of re-trafficking. So that's how we get to that point. And then we come to the upper tribunal, which is their findings, which is importantly,
36.
so
Tab 7.
back to tab 7 page.
Yeah.
Can I just also take you to paragraph 10 of the upper tribunal, which comes from the Rule 24 reply, which is in the bundle. I don't necessarily have to go there at the moment if we don't need to. The claimant filed the Rule 24 reply. That's the appellant before this court, who's now before this court, relying on the report of Professor Siddle. There would be a risk of real risk if returned to the Philippines, because she'd be returning to the same socioeconomic circumstances. Trafficking for Filipino domestic servants was common, and Filipino servants were in the Middle East were extremely vulnerable to ill treatment and abuse. The judge's conclusions, so that's the key point there in Rule 24 reply. Paragraph 10, the respondent had accepted the victims of trafficking were a particular social group. The question for the tribunal was whether there was a real risk she'd be subject to abuse and exploitation again, abuse and exploitation as a result of being forced to seek work abroad. The evidence showed that it would be likely that the claimant would be driven to seek work abroad where there was a real risk that she would be persecuted. And that was the way that the appellant's case was put to the upper tribunal. So, I mean, we only pray that in aid to say that is exactly how the case was put to the upper tribunal, and so that the upper tribunal were wrong to have found the material errors they did in relation to the first-tier judge's approach and set it aside, And you'll note also, as you can see, before they say remaking the decision, that the material facts are not in dispute. No, that's paragraph 22. No further findings of fact are required. Neither party sought to rely on additional evidence, and then they remade the decision without the need for any further hearing. So that's how we characterise the errors of the first tier of the upper tribunal in interfering with the first tier, and then we come on to the core question that we now are before. If we move on to ground 2 before this court, which is the way that the upper tribunal decided to examine the question. If she returns to the Philippines, so no, due to poor economic circumstances, she might decide to work again because the work is fine in the Philippines. If she chose to do so, she would face a real risk of suffering the same treatment she previously suffered. Well, it's reasonably likely that would happen. I summarise, not capable of mounting to persecution within the Refugee Convention. So there was no, even though the PSG was raised clearly in the Rule 24, there was no comment on that or finding on that by the in any further finding or observation by the upper tribunal in reaching their decision. Their sole reason for rejecting her substantive claim was because they said that their conclusion was that if she decided to leave her country of origin of her own free will and pursue economic opportunity abroad, she wasn't entitled to protection of the Refugee Convention and any risks they face outside their country of origin in doing so. And that's where both the error arises in relation to defining the question about choice, but also confining the risk that they face outside the country of origin without connecting it to the trafficking history which was the way she put her case. Or they could have rejected that history. They could have rejected that, said there won't be a risk of being re-trafficked in the Philippines. But they didn't. Actually, the error, the second error, as we identify in the grounds of appeal, is it would only ever arise outside the Philippines anyway. So for both of those reasons, the upper tribunal decision cannot stand. And we say that applying the principles that we just looked through in Ahmed and HJ and RT, that if on the facts she would in fact act in the way that has been the first tier tribunal found and was entitled to find, she's entitled to the protection of the Refugee Convention. And that's what the protective principle of the Refugee Convention establishes.
If we're against you on ground one and with you on ground 2, what do we then do? In other words, if we think that the upper tribunal judge was right to set aside the first tier tribunal judge's decision, but accept your submission that the upper tribunal judges were wrong, were at fault in the way they conducted the remaking of the decision, what do we then do?
In these circumstances, even though the facts are not in dispute, there are questions that need to be remitted to the tribunal for further finding, we say.
What questions?
If the upper tribunal were right to set aside the first tier tribunal, then there needs to be a determination of fact. So if that's assuming that there needs to be a determination of fact as to why she would seek work abroad and whether there's a chain of trafficking that starts in the Philippines.
Well, those fact findings have been made by the first tier.
And if those are all accepted, then the next question that arises is the way in which the convention reason is articulated, and that wasn't as we've been at pains to identify. That wasn't an issue before the tribunal that was fully argued. It did go by way of concession. It might be thought to be appropriate to remit that question. It might be thought that this court has heard argument on it from me, at least. But I'm just reminded about my instructions, which was it wasn't articulated below because it was never further articulated other than in the Rule 24 notice, which I've made reference to. It's at paragraph 10. It's in the core bundle. and it wasn't the subject of any findings any detailed findings by the upper tribunal. One would expect an upper tribunal, if they were going to squarely confront the question of a particular social group and the entitlement under the Refugee Convention, to do more than those 3 paragraphs because that's the redetermination. It's not just the error of law finding, that's the redetermination.
Well, if we thought we ought to, if possible, to remake the decision ourselves, test your argument.
Yes.
How would you suggest our decision should be couched? And then we can decide whether we have the material to make it.
Well, I've taken the court through the sort of principle and structure of decision in the
Yes.
fauna and so on. I'm conscious that right from the outset, the question had gone by way of concession. That's the difficulty, which I think Lord Murray in his skeleton argument says there was a deliberate consent. That's right at the end of the skeleton argument. I think it's paragraph 57.
There was a difference before and after the
Yes,
CPIN,
and
yes.
I struggle to identify what that means and how it manifests itself, but I'll wait to respond to Lord Murray on that. But that was the claimed, without any further evidence, but on submission, the claimed distinction between the position as it was put in EAV and the position as it's put in GMP. But
It depends on the source materials, because the pre the CPIN, there was something that came out of the United States, which is quoted, I think, specifically in the decision letter. And then the CPIN comes in, which actually is better informed and which looks at the matters in the round. But I mean, there are gaps in the CPIN which we can explore with Lord Murray.
I mean, in the conclusive Brown's decision in EAV's case, they specifically refer to the Trafficking in Persons Report 2021.
That's right.
Which supports her claim to be not only a victim of trafficking, but why then that's used to inform why she's treated as a former victim of trafficking. I can't see, having looked at the 2022 report, which is the one in the bundle, the authorities bundle, and again, maybe just thinking about time, I may need to reply. That was how I chose to deal with that question, dealing in reply to Lord Murray, because I can't see a material difference that would change the definition of the trafficking PSG, former victim of trafficking, from those materials. And myself and Miss Lou have been examining that question.
Well, should we park my question to you about how we should do it if we remade the decision to refer to Lord Murray?
The real issue is really whether the question has been correctly asked by the reference to the PSG and the tribunal, the upper tribunal haven't done that, as we say.
Right.
So that would be why we focus on.
So have we dealt with EAV and now
I think there's anything else to say?
GMP? We can take this slightly more quickly, perhaps.
Let me just take GMP. So again, in her case, her core claim for asylum was accepted by the Secretary of State. That's at C57. Paragraph 18, I think it's the decision. Oh, sorry, it's actually paragraph 18 of the first tier tribunal. We don't have to go back to the decision letter. The judge says at paragraph 18 of the first tier tribunal, that's page 57 of the core bundle. As I've laid out, much of the appellant's core claim for asylum has been accepted by the respondent. But she reiterated, and then there was a question about the timing of her claim, but there's nothing material that arises from that. And then at paragraph 21, she also accepts the core part of her claim, which is going back to paragraph 5. You can see the findings of fact there by the judge. just importantly, extensive information, personal history, all of those things which are accepted. And she seeks to detail the points which she says are ultimately material to the relevant assessment of the Refugee Convention claim. So 5C, she was the breadwinner for the children because the husband had stopped supporting them in 2012. She had to seek paragraph C to D. She had to seek employment abroad in order to support her family. But, that's
That, of course, was at a time when they were much younger. There's findings of changes of factual circumstance, aren't there?
There are some changes of fact in the sense that she has less dependents, but she still has 2 dependents plus the adult dependent, 2 dependent children who she's solely supporting, and the adult dependent.
The adult dependent is
Although
working.
she's
isn't
worked, she does undertake some work, but critically that she has, instead of having, I think it was 5 children, she has 2 minor children. But and she also, just for the court's note, we probably don't need to go there. In her witness statement, I know I took you to EAVs, but for the purposes of your note, that in her asylum witness statement, paragraph 40, supplementary bundle 141, GMP supplementary bundle. So she was deceived into believing that a good job awaited her. That's at paragraph 6B. That comes from the positive conclusive grounds decision, which is recorded in the determination there at 55. She couldn't leave. Part of that, you don't need to go there perhaps again, but for the purpose of the court's note, in her conclusive grounds decision minute at S173, her employer had held her passport, so she was unable to leave. So that was one of the things that incidents that occurred to her. So like EAV, she was only able to escape in 2017 when she was assisted by a friend and a domestic violence charity, I think is also correct, in the UK. And she says that, and she remains responsible for her 2 children. Paragraph 47 of the determination. And the other family members cannot assist because they themselves are struggling even though they work. That's paragraph 43 of the determination. So those are her factual circumstances. She says if she's sent back to the Philippines, she won't be able to find employment to support her children. That's at paragraph 57 of the judge's determination, which in turn refers back to her witness statement at 190, which is in the bundle. Bundle, I should say. Same is true from that she also consistent with what was said to the psychologist, and what she, as recorded in fact 56 and 57 of the first tier tribunal, she fears being forced to apply for another job overseas and fears exploitation that may occur there. So we say, in short, against the backdrop of that credible evidence, there was no proper basis for the first tier tribunal to reach the view that she did at paragraph 58. That it wasn't reasonably likely that she would endanger herself by seeking employment abroad. And
the judge has given 1, 2, 3, 4, 5, 6, 7, 8 credible reasons for making that fact finding.
Well, I accept all of that except for the core proposition, which was why I took the court to HJ Iran and RT Zimbabwe and Ahmed. Which is the first, which is the past persecution is indicative of future risk. In this context, we maintain that. But secondly, and most importantly, it's clear from the judge's analysis that she says, that she doesn't disagree or find anything the appellant said is not credible. She says that she's formed the view that it wouldn't be reasonable, that the appellant wouldn't reasonably likely endanger herself. So she's relying on the appellant's self-protective mechanism, like I'm relying on the Iranian gay man not to go out and tell people that he's gay or act in a way that's consistent with his identity. That's how we.
Is that a precise analogy?
Well, we say that there isn't any authority that I can take the court to directly on point. I accept that. It is part of the Secretary of State's case in HJ Iran, which was rejected by the House of Lords or Supreme Court, I can't remember which one it was that it was reasonable for some.
Mr. Ravinder Singh, Queen's Counsel, that he then was.
I think that's probably right. Part of the learned Secretary of State's counsel was that it would be reasonable for the individual to act, and it was out with the mechanism, the protective mechanism of the Refugee Convention, if it was reasonable to expect someone to.
But this is
conceal.
not reasonable in that sense. I'm sorry, you're eliding two concepts. Not reasonably likely means it's unlikely to happen, right? That's something quite different from acting reasonably or not acting reasonably. So,
yes, I accept
what the judge is saying, I thought it was a he rather than a she. I think it's First Tier Tribunal Jarvis, isn't it, Paul Jarvis? I have ultimately formed the view that it is not reasonably likely, i.e. I'm not satisfied that she would seek to endanger herself. Let's take the word seek to endanger herself out of this for the moment. By approaching an agency. In other words, I'm finding as a fact she would not approach an agency to seek to work overseas. Here are all the reasons. Yes, he's coloured that by saying seek to endanger herself, but that is because of all of the fact findings in the past about how she is saying, I find it would be difficult to cope, I'd be forced, I can't even think about it, etc., etc.
But my lady, I accept that he has given, Judge Jarvis has given a series of reasons, but they're all premised upon this is our submission, and it's analogous as far as we can make it with HJ, that she would not, even though she suffered past persecution, the reason she's not going to put herself in that situation again is to avoid the persecution. That's the circularity of reasoning that the court rejected in HJ. And that is the core of how we put our case.
So you say it's on all fours in that sense.
In that sense, that's the closest we can put it. The assumption made by the tribunal is that you would want to avoid the persecution happening to you again because it did before, and therefore you'll curtail your behaviour. And that's exactly what we said. That the protective purpose of the Refugee Convention that was identified by the court in Ahmed, and which I've taken you to, and the subsequent Supreme Court decisions in HJ and RT.
Without wanting to prolong this, I mean, is there a distinction between someone taking steps to conceal something innate about themselves, for sexuality, and somebody, through a combination of reasons, not doing the same thing they did before? If you look at these reasons in A to H in 58, doesn't the judge identify a range of factors which led him to the conclusion that she wouldn't approach an agency to seek work overseas? And they include for example, she's had expert assistance, she's educated about the risks to exploitation. That's D, I'm reading from D.
Yeah.
Not likely well, you see my point. That if you go through it, it's not the same as concealing a truth about yourself because of the fear of persecution. It's for a combination of reasons she's not going to do it. Some of which may be fear, but there are other factors at play here.
My lord, what we would say is if one of them
is
fear, and that's what we submit in danger is, that it is material. He has given other reasons. I can't shy away from that. But if you materially start from the question that you can avoid the persecution by doing something different, the question, and the upper tribunal has looked at in EAV, and the approach of this tribunal is, was the judge entitled to reach that conclusion? It's all about whether it was reasonable to do that. And we say, in order to avoid the persecution, that's the circularity that we're saying that we should avoid. And in answer to my Lord Justice Baker's question about is it on all fours with innate characteristic in HJ, it may not be entirely on all fours, but coming back to the RT scenario, that's not an innate characteristic not to have any political belief. That was just the court accepted that following from somebody should be required to profess a political belief if they didn't have one in order to avoid the persecution. That shows you that if the court applies the broader interpretation of in the human rights framework context, that what the appellant is seeking to do is to avoid being trafficked. The risk of trafficking comes from the trafficker, and the lack of protection comes from the state. It doesn't come from her action. She's indicated, and her appeal statement was, again, I'm just going to give you the reference because of the time. It's in Supplementary Bundle, tab 13, at page 137. But the conclusion, her evidence at paragraph pages 157 to 158 was that if I'm sent back, I don't think I'll be able to find employment in the Philippines to support my children. I'm afraid I'll be forced to apply for another job overseas. I can't even think about that. It's too hard. I wouldn't be able to cope going through that again. And then she goes on to talk about her other personal circumstances.
That's actually quoted in the decision, at paragraph 57.
Yeah, sorry, I realised there was a reason why I haven't gone to that. But the point that we make here is that the appellant is it is clear, even though there are other reasons given, that the judge was trying to reach a factual evaluation based on it, including whether somebody would put themselves at risk of that harm. And that was the mischief in Ahmed that was corrected by the Court of Appeal. You wouldn't go and proselytise if you knew the Pakistani authorities are going to come and beat you. You wouldn't do that. And that was why the court corrected that analysis. So in focusing on her expressed fears of further exploitation, which is how she put her case, the tribunal ignored that credible evidence and the expert evidence as to what the risks on return for her were, and reached those conclusions. We say there's an error in that approach, and although other reasons are given, it is material, and those were then upheld by the upper tribunal. And we should just go back to that upper tribunal decision for the sake of completeness. It's upper tribunal deputy upper tribunal judge signs at page 35. So he sets out the essence of her claim, was paragraph 3, faced with trafficking because of her circumstances. There. Sets out the material findings by the judge at 4, and then refers to Professor and the positive reasonable grounds decision and conclusive grounds decision at 4N 37, and Professor Siddle's 2 expert reports, none of which was contradicted. And at H, so that I think that's, what is it, H? 5H, the claim was the appellant would be at high risk of re-trafficking because she's the main breadwinner for her family, and would have to borrow money or enter an agreement with an agency to secure work in the Middle East, which would exacerbate her vulnerability. And then the addendum report. So the conclusion, and then the professor's conclusions at 5K was her needs and expectation of survival, that she's very likely to seek to resume work in the Middle East. The psychologist's evidence, and then the grounds of appeal said paragraph 9,
yeah,
which is set out there. We don't need to go to that. And the court's decision, as I indicated when we opened at paragraph 13, it comes to 2 simple points. Whether she could be driven by force or circumstance to work in the Middle East to contribute, and in the context of that accepted risk. So we didn't get permission on the procedural fairness ground, so it comes to the reasoning of the tribunal which is in relation to the findings of the first tier, which is the was this tribunal entitled to uphold the findings of the first tier on those facts? And the final conclusion is at 21, which is, he says, the instant decision was within a range of lawful responses to the evidence it was presented with, and comments on the quality of the evidence, and says it's a disguised sort of irrationality challenge which took account of the full scope of the evidence before it. The inferences are not illogical. So we say, our submission is, in short, that the tribunal didn't ask itself the right question in relation to the question of whether it was entitled to categorise her case as one of not choosing to endanger herself. And that, if it's accepted as an error, is necessarily material to the outcome. And so I think that really is all we can say in respect of EAV. If you're with us,
GMP.
GMP. If you're with us on
Yes.
on the error being material to the determination of the first tier, then that should be remitted to the upper tribunal. Yes, well, it could be then remitted back to the first tier.
Yes,
that's where the error
I was going to say FT.
I mean, it's right to say, of course, that we recognise there's no authority on the proposition that my lord and my lady has been seeking to draw me to. All I can present, how I can only present my case, is to say, taking those principles and the protective obligations under the Refugee Convention, the broad humanitarian objective, and the principle to enjoy fundamental rights and freedoms without discrimination, that's how to construe those questions, and that both tribunals fell into the error of looking at this as a question of choice or avoiding danger, and that's where we say that they were wrong. For those reasons, we say that the appeals should both be allowed.
Where do you say that the error of law that you've just identified appears in your grounds of appeal on page 45?
Or GMP.
GMP, fair.
I can't see anything in there in relation to HJ, Iran, or
in 1.1, the way it was categorised was, that's page 45, which was that it was unfair, which is a point that we haven't got permission on, and two, that the evidence before the tribunal wasn't capable of supporting the conclusion that there was no reasonable.
That's a rationality challenge.
Ultimately, if it's a fact-finding question, it falls to, it's not rational for the tribunal to have concluded that she would not seek to endanger herself. But to make good that argument, we put it in the context of why that is wrong as a matter of construction in relation to HJ,
right.
Iran, and RT. And it is also right to say, just in the context of HJ, as when I took you to Lord Rogers, and what the tribunal should do, they have to make a finding of fact. That's what he indicated, as to why a person would conceal their identity. But that has to be consistent with what the protective object of the Refugee Convention is, which is not to require people to conceal matters which are intrinsic to their identity. And we argue by analogy that she shouldn't be required to conceal or to fail. She shouldn't be required not to seek work abroad, or that shouldn't be a material factor in the circumstances where the risk of free trafficking comes from the trafficker and the lack of state protection. And the only rationale would be if the tribunal had found that she just wouldn't do that. But the tribunal found that she wouldn't put herself in danger because it would endanger her, which is the circularity point that the tribunal, that the court in HJ ultimately overturned. Then I can't improve on that, but that is how we put that. Thank you.
Anything else?
If I can assist any further, thank you.
Ms. Naig, thank you very much. Lord Murray. Without in any way wanting to put you under any pressure, have you any idea how long you're going to be?
Well, given the exchanges between my lords and my learned friend, I've been able to excise quite a lot from my proposed submissions because I can clearly see that the court have read it in great detail.
We've had the benefit of very helpful submissions on the law, and we've been through the case law, thanks
Exactly.
very much to Ms. Naig's help. So we probably don't need to
So I
go through all those cases again.
quite, and I simply I can make my submission, and it's points that the court have already identified, and you can simply say yes, that's a point that the Secretary of State makes. If I may, though, I would say that I hope to be done in an hour, but maybe less. But we'll see.
Well, let's see how we go. I mean,
If my
we through our interventions, Miss Naig was longer than she optimistically thought. Well, we encouraged her to say she was more realistic first time round, I think. So don't feel under any constraint to finish today. Obviously, we'd like to, but don't feel under any pressure at all. Okay?
Thank you, my lord.
Yes.
If you're not, if my submissions aren't helping, or you've already reached it, just move me on. I'm sure the court will not be restrained in doing so. May I turn immediately to a topic that has clearly interested the court, which is the question of why the Secretary of State conceded the PSG point, and what the PSG point is. And I just want to take the court to one or two documents, because the position is actually different between the two cases. As my Lady Justice Andrews has already identified, now, in the case of, and this turns on the timing of the CPIN, in the case of EAV,
Yes. That's right.
which was the decision letter was promulgated first. In the, if we can just go to
Core bundle.
the core bundle for EAV,
Last document.
we can see it exactly. My lord is well ahead of me. We can see in that document, just go to the front of the document, obviously it starts on page 67, the determination notice, and then the reasons for the decision start at page 69. And in my learned friend's skeleton, at paragraph 44, she said that the Philippine authorities were unable to protect EAV from illegal recruitment practices, which the SHG accepts are prevalent in the Philippines. And she relies upon paragraph 17, which is on that page 73 and 74. I would just say, in passing while we're in the document, that I can't find that passage in there. And in fact, it's to the contrary, is set out at paragraph 38 on page 76, where the decision maker says, based on the background country information considered in the evidence you have provided in support of your claim, it is believed that the authorities in the Philippines are able to provide you with effective protection to the appropriate staff. So I just wanted to make that point while we were on this document, and then returning to the recognition issue and the PSG question more generally. What we have on page 77 is the determination from the decision maker, and
Yes.
on the decision letter, and I can't immediately lay my finger on the paragraph. Yes, 71.
Page 71?
Yes, so if we go to page 71 at the bottom under the heading Convention Reasons, we have at paragraph 9, the text, your claim for asylum is based on you being a victim of trafficking as a particular social group for the Philippines, a member of a particular social group, a reason not covered by the Refugee Convention. I have considered your claim to be a victim of trafficking, whether this means you are a member of a particular social group who cannot return to the Philippines, because it means you're at risk of persecution on this basis. For any group to be considered as a particular social group, those who belong to the group must share an innate or immutable characteristic and have a distinct identity that will be perceived as different in society. And of course, we recognise the roots of that test from the authorities that Millen Fred took the court to a couple of hours ago. And then at paragraph 11, as defined above, it's been concluded that as a victim of trafficking is a particular social group in the Philippines, according to the USSD 2021 Trafficking in Persons Report, the Philippines is a Tier 1 country. Victims of trafficking share a common background, and the USSD report notes that human traffickers exploiting domestic and foreign victims both in the Philippines and abroad. And then if you just turn the page to paragraph 13, in the final line there, you can see that the decision maker says, as a result of the background information that's been accepted, your claim falls under the PSG Convention. Now, of course, as we noted when we first looked at the document, the date of that predated, which is the 22nd of June, predated the CPIN, which we have in the authorities bundle. I could just ask the court to go to the authorities bundle. It begins at page 120, tab 9 of the authorities bundle. Let's just go to the first page, page 120. We can see that obviously the country policy and information note, human trafficking, Philippines, November 2022. And the relevant page is at page 128. And just by way of a little run up to the wicket, on page 127, we can see that there's a direction to decision makers that they must consider whether there are serious reasons for considering whether one or more of the exclusion clauses is applicable. If the person is excluded from the Refugee Convention, they will be excluded from the grant of humanitarian protection, etc., etc. And then there's the excluded paragraph 2.1. And at 2.3, we have convention reasons. And at 2.3.1, the CPIN makes clear potential victims of trafficking are not considered a form of particular social group within the meaning of the Refugee Convention. This is because they do not share an innate characteristic or common background that cannot be changed, or share a characteristic or belief that is so fundamental to identity or conscience that a person should not be forced to renounce it. And they do not have a distinct identity in the Philippines because the group is not perceived as being different by the surrounding society, a point that my lady, Justice Andrews.
So just pausing there, we know that traffickers prey on vulnerable, economically vulnerable persons, and that possibly more often women and children, but also some men. So on that basis, it said that one couldn't say that a PSG would amount to a group of economically vulnerable persons in the Philippines because they're not regarded as a distinct sector of society.
Yes.
That's what that is saying.
Yes. I share my lady's view on that. And the particular reference is then made at paragraph 2.3.3 that women and children who've been trafficked for the purposes of sexual exploitation are likely to form PSG. Yes. And the logic behind that is set out in the following paragraph. Perhaps I could just invite the court to read that paragraph.
You rely on the last part of that.
Exactly.
That there is evidence of particular societal attitudes towards people who have been trafficked for that purpose.
Exactly.
So, whereas you could certainly argue that there is a common background or innate characteristic that can't be changed amongst people who have been trafficked in the past, or people who have been trafficked in the past, because they've all got the experience of having been trafficked. And women who've been trafficked for domestic purposes will have got that common characteristic. But there is not the evidence that suggests that they are treated differently from the rest of society or perceived as a separate group.
Yes, that's absolutely right. There's no evidence to suggest that. So the
But then what's puzzling me is why they were treated as a separate group before the CPIN.
well, as my lady observed in the exchanges with my learned friend, the reliance upon the US document, which we have in the authorities bundle, provides the basis, and the thinking had clearly evolved by the time of the CPIN. Perhaps I can just bring matters back to this case and then look at the GMP decision, because it was never said in GMP that she was a member of the PSG. If we could go to her decision.
Yeah, I spotted that. I mean, in her case, really, the focus was much more on domestic violence and the fear of domestic violence and re-trafficking.
Exactly so.
Very secondary.
So we have her decision, which the reasons commence on page 73 of the core bundle in GMP's case. And we have obviously the usual account of information for the decision maker. And then at page 76, there begins to be a table setting out issues and material factors accepted or not accepted by the decision maker. And one can see that on page 77, at paragraph 2.3.1 at the top of page 77, the decision maker notes that potential victims of trafficking are not considered to form a particular social group within the meaning of the Refugee Convention, which is of course drawn from the CPIN.
So it's a direct quote, isn't it?
Indeed, and then the following paragraph, and then the material factors accepted are set out that she was a victim of trafficking because she was served with a positive conclusive grounds decision and she was abused by her ex-partner, but there's no reference to her being accepted as a member of a particular social group for the purposes of the convention. And if one does turn to the page, you can see under the heading well-founded fear of persecution that the decision maker was not satisfied that her claim for asylum was on a reason covered by the Refugee Convention, and that's consistent with that finding. And of course, as my lady observed, the bulk of that decision turns on the allegations in relation to domestic violence. And then it's perhaps of note too that the question of protection arises and is covered by the decision maker, and that's at page 79. And the decision maker concludes that he's satisfied there was a reasonable degree of likelihood you'd have access to protection from the state in the Philippines, and that was in relation to the grounds then advanced, which included the domestic violence claim. Obviously, in the appeal to the first tier tribunal, the issue was not raised, and there is no sign. If we go to the first tier tribunal decision, which commences on page 52 of the core bundle.
Which one are we in?
This is Judge.
GMP?
Yes.
This is GMP's decision. I'm simply showing the court that there's no suggestion of an agreement that GMP was part of a PSG for these purposes, because there obviously wasn't an issue before the court, before the tribunal on that occasion. Whilst the relevant background is set out in relation to her history and the fact of the positive conclusive grounds decision, it's not said or not recorded even as being a submission. And in the findings, the first tier tribunal judge sets out his understanding of the evidence, and paragraph 33 on page 59,
Yes.
the judge deals with the risk of re-trafficking, and he notes that counsel, Miss Hurst, as she then was, had set out the risk of re-trafficking. It arises not within the Philippines, but from the applicant being compelled to seek work abroad, and specifically in the Middle East, where she would face a real risk of further
That was why I
modern
was trying to row the upper tribunal out of the problem, because that was the point I made to Miss Nate, that council was not looking at it in the holistic way that we have been rightly shown in terms of trafficking. And I don't think you would dispute that the trafficking, from what we've seen from Miss Nate, covers the whole of the process from the beginning to the end, including the recruitment.
Yes. So slightly surprising submission from council, but
Yes.
but the tribunal judge could only work with the submissions that he had.
Shame that the Home Office presenting officer didn't put him right.
All right.
I think
Or her right, sorry, yes.
yes. Yes. I can only agree with you, my lady, on that.
Sorry,
It is Judge
I meant
Jarvis.
the council.
The council, right, yes, yes.
Council, right. You meant the judge.
Sorry.
Yeah.
Well, what is it right? I mean, yes, I assume that the judge has accurately summarised council's submission.
Yes.
Either way, it's a wrong. The assertion is wrong.
Wrong, yes.
You accept that?
Yes, it's wrong in the law, I think. In any event, the grounds of appeal, as my lady observed, which are then brought against this decision in relation to GMP, again, don't particularly raise. Forgive me, I'm looking at it through the lens of the PSG point.
Yes.
They don't raise PSG as an issue, so and it can't be open to my learned friend here to criticise the judge for not examining the PSG point in great detail. And as she fairly says, it wasn't an issue that was discussed with the tribunal. Well, it wasn't. But that doesn't mean that it
Does
now.
that really help you though? Because isn't there an assumption? Isn't the working assumption that they are members of it, or that she is a member of a PSG? Because if you don't get past that, you don't get into the whole question of risk or sufficiency of protection. It's just an oversight. Nobody's actually addressed the right questions.
I think that's right.
Yeah.
But in terms of
But I suppose you might say, on the other side of the equation, well, let's say that the judge did, for whatever reason, not think about this, but made assumptions in favour of the appellant. Nevertheless, her claim failed because of the findings of fact that were made at the end of the day.
exactly, and that was the point I was just about to make. So and then we have as you say, the 8 points she sustains that were carefully set out in the First Judge Tribunal's decision that are expressed in trenchant terms in the paragraph 21 of the Upper Tribunal Judge decision on page 43 of the bundle. And I would submit that the ground of challenge that in some way the Upper Tribunal Judge's decision should be upset on the basis that he applied the wrong test is misconceived in those circumstances, because he was only he had to adjudicate the appeal on the grounds that were before him, and he considered the relevant matters, and he reached a lawful and appropriate decision.
The FTT or the UT?
The UT. Obviously, this is an appeal against the UT's decision. So I'm talking about
Yes.
Page 43, paragraph 21.
I think it's put on the basis that the UT should have found an error of law in the FTT decision.
Yes.
Used on the basis of the way in which it was argued in front of him, there was no basis for him to do that.
Exactly.
We haven't looked at the extensive, well, I haven't, or in the hearing we haven't looked at extensive grounds of appeal beyond the first page. The grounds are set out more extensively on pages 46 onwards.
They are. In fairness to my learned friend, my lady Sanders put to learned friend whether she was making those points that she now makes, and the answer was no. But she my learned friend pointed to paragraph 1.1 of the grounds of appeal, and they were correctly characterised in my submission firstly as the process challenge, upon which permission was refused.
Yes.
And then what is in on analysis of rationality challenge, which is what paragraph 21 is directed towards. I hope that, forgive me, and then...
Well, that may be the short answer, but I would have thought that for the sake of completeness, I for one would like to know what your answer is to Miss Nake's ingenious interpretation of paragraph 58, and in particular to the point that she makes about the endangerment point, because this appeal is going to have potentially wider implications than for the facts on these particular two cases, and whether or not it is an error of principle in a case such as this to, whether it was material or not in this case doesn't matter, but to define the risk or likelihood of putting oneself in risk in the way in which the judge has, and it's the words would seek to endanger herself, I think, are the words that Miss Nake particularly lays stress upon.
Yes, and obviously we touched on this in the permission hearing. Obviously, the reason that this case crossed the permission threshold was for that reason, because there may be broader points. And
yes.
Obviously, I would submit. If I could just turn to the paragraph.
Page 64, paragraph 58.
We need to read it in context.
Yes.
And the Learned Friends' genius argument perhaps gives undue weight to the seek to endanger yourself element of the sentence, because one has to read it as a whole. And where the judge says, I have ultimately formed the view that it's not reasonably likely that the appellant would seek to endanger herself by approaching an agency to seek work, thereby making herself vulnerable to further modern slavery, and then sets out the 8 reasons. And they are considerable and detailed. One of the factors that the judge was plainly considering was that this was a lady who had been recruited as is accepted, and was deceived in the process of doing so, and had a very nasty experience. And it is legitimate, in my submission, for the judge to say that if one has that experience, you're going to be more cautious about taking the same course, particularly in circumstances where her personal circumstances have changed. We know, for example, as the lady has already identified, that the need for expenditure has reduced because of her changing and ageing children and her family circumstances. And accordingly, it's legitimate, I would submit, for the judge to have considered whether or not the appellant would seek to take a job abroad in the circumstances of her own recent experience. And I think the weight placed by my learned friend on the word reasonably in that context as being an inappropriate use of the word reasonably is misplaced. It seems to be that it just has to bear its ordinary natural meaning, that it is not reasonably likely. It seems to me that it does stand to reason that somebody in those circumstances would be more cautious in taking the job. Now, my learned friend says, oh, but the economic circumstances are so dire that she would do it anyway. Well, I'm not sure the evidence sustains that. And certainly the evidence that was before the judge on appeal didn't sustain that, and he didn't consider that it did. So on that basis...
Well, B and C are problematic from the appellant's point of view. The particular point that struck me is C, that there was a period when the appellant thought she wasn't able to work. I mean, unfortunately, that view was misplaced, but it meant that she wasn't able to send money back to the family, and they managed.
Yes. And there's also the question which arises in this case of internal relocation, which hasn't really been addressed. I mean, it's touched on in C because, of course, there is more.
But do you say that the analogy with HJ Iran
I'm coming to that.
is a good or a bad one? Because that I think is the nub of all of this.
I think it's a bad one, my lady.
Yes.
And I say that because HJ Iran is a specific case which related to a protected characteristic of sexuality and presentation, and there were very good public policy reasons why the court said it was consistent with the convention for there to be an entitlement to live without having to be discreet, if I paraphrase the decision. That doesn't arise, and it can't. It seems to be straining the analogy beyond its natural breaking point.
What about the RT decision, which was to do with, sorry.
Forgive me, I'm so sorry, my lord. So it seems to be straining the analogy with HJ, because in these cases, the fact that you've been trafficked, there's no, as we exchanged a moment ago, there's no evidence to suggest that there is any particular stigma or any reason why you would need to be discreet about having been a victim of trafficking. And then just turning to the RT decision, obviously in RT, it was clearly a decision on its own facts in relation to the politics of Zimbabwe. And again, a conscious decision, a principled decision by RT in that case to adopt a particular political viewpoint. But that's very different to the facts of this case, where clearly there was no agency in these two very unfortunate instances of trafficking. Again, I would suggest that the analogy can't be sustained with either of those lines of cases. I'm afraid the court can draw little assistance from them in the context of this case. Forgive me, my lord, did I answer the question you were about to ask?
Certainly, given an answer.
Can I just on the authorities? No, I think that's probably enough. You've covered. I don't want to waste. There are various points that I think are now unnecessary. Turning then to EAV, if I may. So the upper tribunal, if I could just go to the upper tribunal's decision in core bundle for EAV at page 39. At paragraph 24 on that page, we can see that the UT accepted that the claimant had previously suffered ill treatment amounting to persecution whilst working abroad as a domestic worker. And the UT also acknowledged in the same paragraph that if EAV returned to the Philippines and chose to work abroad again, due to poor economic circumstances, she would face a real risk of suffering the same treatment. I raise that because, of course, there was an exchange about whether one can choose to be a victim of persecution. That it seems to me is to slightly miss the thrust of what the judge is trying to say in this paragraph. The point that he's making is that on the evidence, it's not an inevitable consequence that EAV will feel that she must take work abroad, and in any event that she must be deceived into modern slavery. I mean, there are many, it stands to reason, and we're told in Professor Symes's report that there are many Filipino working overseas who are not in trafficking situations. And so there are a number of potential variables which don't offend the idea that you can't choose or not to be a victim of persecution. That it seems to me there are too many hoops to go through before you can make that assertion.
There isn't any reference to PSG in these paragraphs, or indeed, I think, in the judgment at all.
No. It is mentioned in the first tier tribunal decision.
It is.
But because it's conceded, it seems to me that the submissions weren't made in relation to it. One point I did wish to take you to was on the my learned friend, towards the end of her submissions, made various points about the Secretary of State's grounds for appeal in EAV. Can I just take you to page 52 of the core bundle in EAV's case, which is the appeal form, and it's to account for the reasons that appeals were being sought. And they were characterised by the learned friend as being somewhat deficient. I would submit that that was perhaps an unfair characterisation. If one looks at the content, the drafter says that the judge erred in allowing the appeals at the first and second line on the basis of what would appear to be contradictory findings. At paragraph 18, he finds the appellant is unlikely to be targeted by an individual. However, they go on to find that the appellant is entitled to be recognised as a refugee, having found that she's at real risk of being trafficked again through economic necessity. It is unclear on what basis it is said to be at risk of persecution in her home country as found, and she will not be targeted. Therefore, any choice she may make for economic reasons and not enforced, the appellant was never coerced and forced into applying for work abroad, and therefore it is asserted that a finding she's entitled to protection of refugee convention is misdirected in law. I have to say, the Home Office official who drafted the appeal says in the same level of confusion perhaps that the court were when looking at the decision of the first tier tribunal in this case, because it is hard to work out how she could reach those two apparently conflicting decisions, and indeed the basis for finding the economic reasons point at all.
Well, it's an absence of clear reasoning, really, isn't it? I mean, it's put on both ways, but on the face of it, you read that particular paragraph in the decision, and you're not quite sure what the convention reason is.
Yes.
Because she doesn't say in terms there's a risk that the same thing's going to happen to her as happened before.
Yes. And she.
You have to read that in. Miss Nake says, well, you've got to read that in because it's a necessary concomitant of looking at the whole of the background, and it may well not have been spelt out, but she says that that's really what the Judge Farrelly was getting at.
And
Which does say, paragraph 20, the first FTT did say this happened before, which didn't say because it happened before.
this is a perhaps a strained construction, but just to return to the appeal grounds again, under ground 3, so this is page 52 and top of 53, one can see that the Home Office have said that they make various points about an apparent conflation between the convention and issues of economic migrancy, as it's described. And then in the final section, furthermore, it's unclear why the appellant's sister, a single individual, is said to be in a better position than the appellant. The Philippines has a functioning economy, whilst her financial remuneration may not be as high as in another country. There's nothing advanced that the appellant would indicate that she'd be unable to find paid employment within her own country. The Refugee Convention is reserved for those who cannot be protected from persecution by their own country's government by virtue of an immutable characteristic. The appellant family's poor financial status cannot be said to meet any definition which would require intervention by the UK government on an asylum basis. And this comes back to the point raised by my Lord Jeremy Baker in his question to my learned friend, because the issues that were before the upper tribunal in the EAV's case clearly also then focusing on whether the adequacy of state protection was a relevant consideration. And in light of that, one can see that the reasoning of paragraph 19 on page 39 is sustainable.
Well, another way of looking at it is that although everybody's going around the houses about it, nobody's actually addressing the correct legal test anyway. What the tribunal is, or what the tribunal hasn't done is said, is she going to be exposed to a real risk of persecution on account of the fact that she is a member of a particular social group? And the causal link has never been addressed by anybody, as far as I can tell. in any of these decisions at any stage or at any level. But it's absolutely critical, isn't it?
It certainly is.
Because maybe what the upper tribunal got at in this case when they redirected is that it's not as a result of a causal link. In other words, the persecution isn't because or on account of or by reason of or even the main reason of the fact that they've been trafficked before, which was the only PSG that was identified. It's because they're economically vulnerable, which is not part of the definition of a PSG.
I entirely agree, my lady. And of course that gives rise to the same problems that were identified in relation to, I mean, there are a very large number of people who are potentially impacted by adverse economic circumstances.
You can think of I've come across other cases, where, for example, in other countries, where there is clear evidence that people who have been trafficked before are either unable to find work locally because of social stigma, and are treated as shunned and therefore have to sort of migrate, and then they can be exploited by traffickers, or even worse, where traffickers, particularly with child labour, know exactly which village they come from and they just go back to the village and scoop them up again. We're not dealing with this scenario. So when one's talking about choice in this context, it's you're not being targeted because you're poor. You're not being targeted at all. And insofar as you're exposed to the risk, it's because you're putting yourself out there because you're economically unable to afford to work in your own country.
My lady,
That's not a convention reason.
my lady puts it much better than I would have done. But that's exactly the point. And I think there's another point that flows from that, just in the context of these decisions, was that the upper tribunal's finding that the first tier had failed to identify a relevant risk of persecution in the country of origin was well founded. The contingent fear of persecution is simply, as you say, is lacking in the necessary causal connection, and in my submission, that's encompassed in the paragraphs 24 and 25 that we have on page 39 in the upper tribunal's decision.
I mean, it doesn't address the points as they've been put to this court. But that's because they weren't. Well, it may be. I'm speculating. They certainly weren't put in the sort of straightforward, full on way that they've been put to us.
Yes,
on PSG.
That's certainly true. And of course, you always would expect a certain amount of refinement as between the levels of appeal on a second appeal to this court, with my own friends' ingenious arguments. One can understand that there a certain amount of latitude must be afforded to judges of the lower tribunal that are making many decisions. And as my own friend observed, there are regular injunctions from this court that the tribunal should keep judgments succinct, and the upper tribunal
Not
certainly achieved
Pots
that.
and kettles might be said to apply.
Yes,
that. As far as I'm concerned. I mean, the points that's raised on appeal does seem to me to be an important point, but your point is it doesn't. One of your points is it doesn't really arise on these appeals.
Yes. I'm afraid that's right. It slightly shoots the fox of my learned friend in that she'd like a determination on this question, and the court may wish to comment on it, but in my submission, it doesn't actually arise on the face of these cases.
What do you think it does? Hypothetical solutions.
Yeah.
Supposing it did arise, what was your case?
Yes.
I mean, when I say supposing, I for my part haven't made up my mind it doesn't.
Of course.
But I can see the force of your argument at the moment.
So, Belenfred's argument is that because, well, I mean, perhaps taking it theoretically and away from the judgments below, is that a person who is in the circumstances of these two claimants, who has been trafficked before, is presently in the United Kingdom, and makes an application for asylum on the basis that if she were to return home, she would be in an economically invidious position and would be more likely than not to, or indeed would be forced by economic circumstance. I appreciate this bit of the argument has moved around a little, but as I understand it, forced by economic circumstance to seek work abroad, and given her previous experience, may be more likely to work for an employer who would return the appellants into a state of servitude.
Actually, I think that's more how it was interpreted by the lower tribunals rather than as put by Ms. Nake. Ms. Nake says fairly and squarely, whether and seeks to demonstrate this was part of the common basis of the proceedings, that these two appellants fall into a PSG because they are previous victims of trafficking,
And therefore particularly vulnerable.
and therefore vulnerable to
being re-trafficked.
be abused in the form of re-trafficking.
Well, I mean, I suppose the first point is, from the Secretary of State's perspective, is we don't accept they fall into a PSG. If we assume that they did fall within a PSG in that hypothetical world, and I always realise it's dangerous ground to go into hypothetical in front of the Court of Appeal, but in that hypothetical world, the court would still, it seems to me, need to, the lower court, considering an appeal against a refusal of asylum, which is, I suppose, what would happen here, would need to evaluate whether that the membership of that PSG, well, I suppose all the authorities suggested is a fact-sensitive evaluation, so it would simply return to an evaluation of the facts as to whether, and it would turn on the evidence that's before ultimately the first-tier tribunal as to whether or not there is whether the risk of being trafficked in the future. I don't know the terminology.
Well, see,
that
from
would
the
be-
EAV perspective, I think the way Ms. Nake put it was that, and she'll correct me if I'm wrong, is that what we have is it's common ground that she's part of a PSG. So the Secretary of State can't get round that now. That's the whole basis on which the appeal was run. Whatever you might say about the other appeal, you're stuck with that finding, or that common ground. So she's party, and the PSG that was so defined is somebody who is the victim of past trafficking, which on the face of it could amount to a PSG if all of the criteria were fulfilled. Assuming that it is, then the question is, if as a matter of fact it is found, and one can't get behind the fact findings, that individual has really no economic choice but to seek work abroad again, all right? And so, therefore, it's found as a fact that she would go through a similar process, and thereby expose herself to at least the risk that she might be trafficked again. Is there a sufficient causal connection between that scenario when she chooses to do it out of economic necessity, as Judge Farrelly put it, and her membership of the group? And Miss Nake says yes, because that signifies her vulnerability. She was trafficked the first time because she was poor and economically dependent on work abroad. That hasn't changed. She's still poor and economically dependent on work abroad, and therefore there's the necessary causal link between the two. I think that's how Miss Nake's putting it.
Yes.
She's nodding at me. So
And she also, if I can just chip in one point, Ms. Nake also runs up a red flag and a klaxon about the use of choice and free will
yes,
in this context, the context of a vulnerable woman who will be subject to what you might call undue influence or some form of pressure.
impelled to do what she
Impelled.
does.
So free will's rather jars in that context, and so is choice. That's how one might say that.
Yes, and I think I touched on that, on the facts of this case, on the choice point. I obviously highlighted what the judge found, but going back to the theoretical, if I may, I think the answer can be found in the convention. If one looks at page 4 of the authorities bundle, it's worth just looking at it again, I think. So the term refugee shall apply to any person who, as a result of events occurring before the 1st of January and owing to a well-founded fear of being persecuted for reasons of ... membership of a particular social group ... is outside the country of his nationality and is unable, owing to such fear, is unwilling to avail himself of the protection of that country. And is unwilling to return to it at the bottom. I think those are the key elements that we need to take. So in the hypothetical scenario, the tribunal would have to be satisfied that that risk gives rise to a well-founded fear. That's obviously going to be a question of evidence.
Yeah.
And then the membership of the particular social group is obviously the hypothetical that we've been discussing. And then obviously, because they're here, the outside country criteria is met. And so we then get to the question of protection within the country. And that's one element that we're just reverting to the question raised by Lord Justice Jeremy Baker. Is it, in the hypothetical scenario, is it the case that a country with worse economic or Tier 1 economic difficulties, as described in the US report, is that something that needs to be remedied? Does a failure to remedy that mean that the state protection is inadequate? Or is it right that this particular provision is targeted at a different scenario? And it seems to me if that latter is the case, then it's going to be very difficult for the hypothetical scenario to succeed. I realise that answering hypothetical questions is always tricky, but
That's tricky.
that is perhaps how I would answer it.
I think you might get some help from the CPIN as well, because
CPIN, does that post date?
So it starts at page 120.
yeah,
Post dates.
it
It
does
post-dates,
post date.
But I think in the hypothetical,
Hypothetically,
about the
you're entitled to
hypothetical.
have it pre or post.
I think in a hypothetical world, I would say the CPIN applies.
2.5, which is on 130. In general, the state is able and willing to order effective protection, but each case will need to be considered on its own particular circumstances.
A person's reluctance to seek protection does not mean that
Make a
effective protection is not available.
difference.
Absolutely.
And then there's references to all the various anti-trafficking devices that are adopted in the Philippines and so on.
Yes.
Miss Nate's response to that is no doubt, but it still goes on.
I mean, there is so just to return to the facts of our present cases, there is the point that is picked up by the judge that the expert evidence is quite dated.
Yes, went back to 2014.
So that is a valid
Yes.
valid issue.
You're gently telling us that the hypothetical question really turns out to be on facts, on factual findings which we don't have the basis.
I am, my lord, and I would perhaps invite the court to exercise caution about describing a factual scenario, because as the court's observed, there are potentially very wide ramifications.
Don't decide anything you don't have to.
But that probably is.
If we concluded, that's the point I put to Ms. Nake, if we concluded that in EAV, that the upper tribunal had been right to set aside the decision of the FTT, but had erred in the way it remade the decision, what should we then do?
Well, it would be open to this court to say that the decision of the UTT was correct, but for different reasons. I don't see any procedural problem why they can't.
And what do you say those reasons should be?
Well, I would.
This is the point I put to Ms. Meg, and she decided to hold.
Can I? There's a kind of yes, a reverse auction. Obviously, my position, the Secretary's position, is that the UT decided the case correctly. So I don't really want to, if I may, identify what may be a different.
But do you say we should make it rather than remit to the UTT?
Well, I suspect that may be the more sensible course, given this court is fully appraised of all the facts and details. And I don't think there's going to be any fresh evidence, but of course that may be a submission from an own friend rather than for me.
Yes. Anything else you want to say?
Wait, may I just check? Yes, the point that's raised in this note is that there's a certain element of circularity to the logic in relation to the causal connection. If the PSG is by reference to being a past victim of trafficking and economic circumstances, it kind of becomes circular in that the evidence in support of the previous trafficking at the time of the previous trafficking is not prevalent at the time of the previous trafficking, then they wouldn't have fallen into the PSG. So there's a risk of circular reasoning. In a hypothetical. I see the point that my client sees to make.
Thank you very much, Lord Murray. We have no further questions.
Thank you, Lord.
Okay. We're going to be able to sit a little later, assuming that's going to be convenient for you, and we're going to be able to.
Yes, I think
Peter
I hope
reply.
to be able to deal with those points relatively quickly, goodness me, just resort my desk. Right, thank you. Yes. So just dealing with the last point first, which is probably a good place to start. I don't accept that the answer to the question about the refugee definition necessarily lies within the question of effective state protection in the forward-looking risk. But if it does, then any appeal would have to be properly remitted for determination of that question, because the evidence that was put forward by EAV, because we're dealing with her case, but at this point on this submission, was put on the basis there was no contention about the particular social group. She put in her expert evidence in response to the issues that were live in the appeal. And if there's a suggestion about determining that question now, then that is a question that ought properly to go back to the upper tribunal
Yes.
to decide.
Well, I think we can see the force of that
Yeah.
if that's where we end up.
If that's where you end up. But just coming back to the starting point in relation to EAV, which is that the particular social group was accepted. We looked at that question. So it's very unsatisfactory for the court to have to deal with this for the first time. I appreciate we've heard submissions on it for much of the day in relation to how it interacts with the error of law. But I would say that Ms. Lord Murray's submissions were that you need to consider and evaluate the membership of the PSG. It's a fact-sensitive question, and it turns on the evidence of re-trafficking. All that demonstrates in my submission that is it's unsatisfactory to deal with it here first. Not to say that it isn't an important point of principle, it is, but that the underlying issue should be clearly articulated by both sides before any appeals are heard on it. Particularly for then being to go to causal link on account of on account of that history. So that's the first point in relation to to EAV. And the second, just coming back to the question of, I just see if there's anything else I want to say about that point first. Oh, just coming back to GMP, it's right to say that at the very beginning of her appeal, I just wanted to take you to, I do want to take you to the document that suggested that the PSG wasn't argued before the first tier tribunal, and that's wrong because of this is the real problem with the way that the tribunals constructed its decision.
Well, core bundle.
So I'm on the supplementary bundle,
GMP.
Page tab 1, page 4. And what you have is a direction from the first tier tribunal now require everyone to file a skeleton argument. And if I take you to page 3, sorry, internal page, so page 6 of the bundle, there's a section on particular social group that goes on for about 10 paragraphs. So the suggestion was that the particular social group was stated as victim of trafficking, and then the alternative one on the facts of this case was about female victim of domestic violence. It sets out the particular principles of law, particularly in relation to this being a post-NABA case, so that's set out in statutory form, and the reference there to the CPIN, which actually we should say potential victims of trafficking, there at paragraph 20. Sorry, it does there say paragraph 20. And so it's quite clear.
There to a country guidance case in relation to Moldova, which we haven't seen.
Yes.
I don't know. I mean, I don't know whether that's setting off a red herring because I'm not particularly aware of that case. Whether that's to do with sex workers.
I think that may be correct, but actually I was meant to look at it and I apologise, I haven't. If it does assist, I will send it to the court after we've finished today. But importantly, paragraph 21, which suggests that there's a lacuna in the CPIN guidance because of what the potential victims of trafficking and victims of trafficking of exploitation does address, but doesn't include persons who've experienced labour exploitation. So it's quite, and that is the whole context in which the way the case was put to the first tier tribunal. And then paragraph 22 contends that victims of trafficking constitute for convention purposes. And particularly here, because although victims of trafficking and potential victims of trafficking were addressed in the GMP decision, of course, she is not just a potential victim, she is an actual victim, and the innate characteristics are because she has experienced that harm, and that was the way in which she put her case. And you'll see there, paragraph 23, the alternative, which is in relation to women in the Philippines about domestic violence. So it's absolutely clear, and I don't think it can be seriously contended, that issue was before the first tier tribunal, and so that it is highly unsatisfactory for the Secretary of State to now seek to argue that that somehow that matter wasn't an issue. And I just remind the court that this was only a refugee convention case because of the fact that the statutory framework in the section, we've seen it in the determinations, it only encompassed refugee convention reasons. There were no other basis for the appeal.
What do you say about the CPIN point?
Well, I'm afraid
Which in this case predated the refusal.
Yes, I'm afraid I don't. I'm still slightly lost as to why that makes a difference to the on the Secretary of State's case. I saw that was in the Secretary of State's skeleton. I genuinely don't understand why it affects the question of the definition of the particular social group.
Because the evidence that backed the CPIN was that if the people concerned had been the victims of sexual exploitation, there was a social stigma attached to them, but there was no evidence in relation to other victims, and that's why paragraph 21 of the skeleton argument tries to draw an analogy between them. And they say that in light of section 5, there's no distinction there's no distinction between the discrimination and stigma faced in the Philippines. I'm going to have to go back and have a look at that section, but I thought it did.
Yes, but mine's, but how that's squared with the concession in EAV, what was that based on? That was based on Secretary of State's position. There's no change. CPIN is a, if there had been a change of material change of circumstances or evidence, but that's not how I read the
The
Secretary.
CPIN's drawn on much wider evidence than the USDD.
But the Secretary of State has only said, I've chosen to characterise it differently. She hasn't pointed to any evidence that supports a change of position. That's why we say she can say that if she wants to, but it doesn't take us any further when the appellant EAV had a concession based on the Secretary. She's basically changed her policy. She hasn't changed any factual evidence-based guidance, and I think that's a better way to characterise it. And I
Right.
know that Mr. Lord Murray hadn't provided any witness statement from the Secretary of State. That's not a criticism, it's just an observation that it seems on any fair reading of the change that it's a change of policy.
Yes.
And that's
Well, it is a change of policy, and it's recited verbatim, isn't it, in the refusal decision?
in GMP.
Yes,
In
in GMP.
EAV we have
Talking about GMP now.
yes. But in EAV it was accepted with reference to, sorry to jump back into the other case, but it was at paragraph 13 of the decision letter. Let me just go back there for a moment, because that was where.
Well, Mr. Lord Murray accepts that there is a stark distinction.
Yes, there
between
is a
the two
distinction
cases,
between the
because in
two.
EAV conceded the Secretary of State
Yes, but
conceded PSG, and in GMP,
not yes, but,
She
and
didn't.
not because of any, as I say, not because of any material change of evidence, which is how I'd understood when I read the skeleton. It was characterised, but it isn't. It's just a policy change. So coming back to that page 72 of EAV's decision letter, paragraph 13. This is why it's a significant number of. I hope we're all there now. A significant number of Filipino migrant workers become victims of sex trafficking or labour trafficking in numerous industries. ... Traffickers, typically in partnership with local networks and facilitators, increasingly use social network sites and other platforms, recruiting unsuspecting Filipinos through illegal recruitment practices such as deception and so on, and contracts to exploit migrant workers in sex and labour trafficking. As a result of the background information, it's been accepted that your claim falls under the PSG, and that's the paragraph we cited in our skeleton argument. I think it was 44, to support the contention as to it's not just a legal concession, it's actually based on, that's paragraph 44 of our skeleton
yes, I'm
argument.
just catching it.
Yes, and it's
Yeah.
consistent with the decision minute in EAV. Again, we don't have to go there, that's the conclusive grounds minute. So we're saying that page 72
Of
that we're just looking at in EAV's decision letter
yes,
comes directly from the CPIN that's the current CPIN, the November 2022 CPIN. So
right.
that's still the objective petition. Let's go to that page, shall
Sorry,
we?
let me find this. So this is the. Oh,
Authorities bundle, page 1.
no, but the decision letter in the
Oh, decision letter.
EAV.
EAV
hold on.
decision letters, page 72, paragraph 13.
Well, that's a quote from the guidance as well as the CPIN.
Yes, I think that's right. But the CPIN is basically guidance.
But the CPIN post dates this decision because this decision was made in June 22 and the CPIN's November.
Yes,
But the quotation, I think, has its origins in other guidance.
yes, it's I think, to be fair, and Lord Murray can correct me if I'm wrong, that quote in EAV's decision in June comes from the previous CPIN. But the quote is repeated in the November CPIN. So what
Which
Lord
particular quote? Sorry.
Paragraph 13.
the quote at paragraph 13, page 72 of EAV core bundle reappears in the same terms at page 142 at 4.55. It's the US TIP report, but cited in the CPIN, which was sidelined. So the important point we're trying to make here is that the evidence, Lord Murray's, the Secretary of State's contention is that we've changed our position on the PSG because there's been a change of evidence or circumstances. But actually, the same exact phrase that was used to justify that there was a PSG, i.e. a well-founded fear of persecution on account of that risk, oh, that was the test you had to meet, arises in the CPIN that was the quote in EAV, which is repeated even after in the new CPIN, and which was relied on in GMP's case. So that's why we say we can't understand how there could be a distinction in relation to the PSG from one to the other. That's because it's the same. It's the same underlying evidence. I appreciate that the Secretary of State has then said we've decided to treat a certain group of trafficking victims in a particular way and exclude labour migrants, but that isn't supported by her own evidence. That's just a change of policy. I don't know if I can say that any more clearly, but that's how it has emerged.
Yeah.
So I think Lord Murray's best characterisation was the thinking had clearly evolved since the CPIN, but it's hard to see exactly how that's happened on the same evidence. So I'll say no more about that.
Thank you.
But I got distracted from where I was.
Sorry.
No, that was this time it was me distracting myself.
This time.
So
As opposed
sorry.
as opposed to all the
that sounds
times earlier
harsh.
in the day.
I didn't really. Apologies. Just one important point in relation to GMP is that EAV. I should be back to that. Is that in the Rule 24 response? So just reminding myself that is at page 41 of EAV core bundle. It's right to say that in the Rule 24 response, there is, I think I'm right in saying, reference to yes, it's paragraph 4, which is EAV saying the tribunal's findings of paragraph 18 must be read in the context not only of the determination of a whole, but also in the terms of the respondent's refusal, which was appealed, and the considerable evidence before the tribunal about risk and return. Importantly, the Secretary of State respondent accepted in the refusal letter that the appellant was a victim of trafficking and accepted her past experience and accepted that former victims of trafficking were a particular social group, paragraph 11. So it was absolutely before both the first tier, as we looked at, and in the upper tier in EAV, the question of PSG was not an issue. And that is just to hammer home. I think the suggestion was that counsel below didn't address the tribunal on that. That's just not correct on the papers. So, and it wasn't, and then it isn't recorded in the determination. Who knows exactly what happened in the determination? But
the upper tribunal dealt with the reply, didn't they?
They recorded
9 and
yes.
10.
So if there was going to be
and included that point.
Yes.
10.
So if there was going to be if that was going to form a material part of their reasons, then we'd have expected more than what we had, which was in remaking when one paragraph, that's it, or 2 paragraphs, 24 and 25. So we say that's why we can make good the defects in the reasoning in relation to the Refugee Convention. Just what I think is probably my final point, which is just coming back to the criticism or analysis of HJ. It said it's a bad one because straining the requirements of the Refugee Convention with the requirement to apply that analogy here, but and because of the stigma about being discreet. But in this case, if the appellant individual were not to disclose the history of trafficking, but were to disclose, for example, that she'd worked in the Middle East in seeking employment, those are the kind of factors that would identify her as vulnerable because of that profile. And so those are the sort of factors that haven't been evaluated by the courts below. Had they have been focused on the causal link question between being a former victim of trafficking and why there's a risk in the future. And I think those are the kind of factual omissions that will need to be re-examined if this court is with us on a remittal to the tribunal in EAV to address those kinds of questions. So I think
Thank you.
that's what I want to say. Just if I might turn over.
Yes, anything you want to try and ask?
If I'm happy that I've addressed everything that I needed to, but I'm very happy to assist any further.
Well, thank you very much. We're very grateful to you for completing the submissions today. We say to Nate, we're particularly grateful to you for responding to our repeated interruptions. I hope you understand that in a case of this sort, particularly where the shifting sands have made it difficult to identify exactly what the issue is for us to decide. And if I say so, the interesting way in which you put the case, it's inevitable that you're going to find some judicial interventions, and I hope that's not distracting you too much.
I'm delighted to have judicial interventions because it helps me frame my thinking. So no
Right,
difficulty with that.
I'll make a note of that.
Yes, for all future cases.
I'll use that in yes.
We always try not to be too interventionist, but
We manage it at about 10,
so,
25.
yes.
Anyway, we're very grateful to you and to those who sit behind you, Ms. Liu, and solicitors for the way in which this case has been prepared, which has made our task a lot easier. Not that it's particularly easy, but it's made it less difficult, let's put it like that. We're going to reserve our judgments. In due course, you will receive a draft in the usual way for you to comment on typographical errors or any minor factual errors, not obviously to re-argue the case. Please bear in mind, as the rubric at the top of the draft judgment says, that it's confidential to you and those to whom it is permitted to be disclosed. Any unauthorised disclosure is a contempt of court. When submitting any corrections, please would you also submit a draft order reflecting our decision in the judgments. Insofar as there are any disagreements between you on ancillary matters, they will be resolved in writing. Short submissions, please, to help us make those decisions. Then the judgment will be handed down electronically in the usual way these days. No need for anybody to attend. Thank you all very much.
Court rise at Fable.